His fellow's not in the area, Darren. What do we do?
Maybe that means he's not a suspect.
Wait. His phone. He turned it off. He's a criminal.
See through you, see your true colors.
Like you, be strong to hold the powers of the sun.
I show you how deep the rabbit hole goes.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I am your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And in this special Friday night edition of The Revealing, we're going to do some revealing because with all of the unsealed court documents, there is so much information that is actually now available to us, some of which we have been, on the edge of our seat for so long. And it's amazing to me because I watched some of the other coverage of this case. Mainstream morons hardly cover anything that's not ridiculous about this case. The minions have moved on to other things, and even the people that cover this case from a fact-based perspective just gloss over so much of this amazing information that we're finally getting to see with our own eyes. They go through and they read the docs, give their opinion, then move on like it's just yesterday's news, and it's amazing to me. And that's why I said, you're going to have to give me a little bit of time with all the information that's been unsealed. I'm going through it piece by piece and bringing it to you and trying to make it have the impact that it should have because it is absolutely unbelievable. And in this episode, we're going to focus on not only one of the released court docs, but what it could have really meant and what it could actually mean if this thing ever does have some movement to it. For almost 3 years, we watched the defense team, the Kohberger defense team, litigate the craziest thing that we have ever heard in all of true crime, this investigative genetic genealogy and how it related to this particular case. And just to give you a little bit of history, I've done some videos here recently on the IGG, but in this specific case, let me just give you a little bit of background. You see, when they arrested Bryan Kohberger and they first put out the probable cause affidavit and told everybody to read it and understand everything you need to know about the case, nowhere in that document was anything about an IGG investigation. Nothing. They left it out altogether. And we didn't really learn about the IGG until the defense started to bring it up in motion hearings. Hey, there's apparently been some kind of IGG investigation that hasn't been disclosed. And then they began litigating it, trying to get all the information about the IGG and discovery. Now, a obscure article was put out early in the release of the documents in this case, long before the defense ever had a chance to even litigate the IGG and begin asking for discovery. And that article was put out not by the New York Times, it was by another New York news source, and it went through and it exposed the fact that IGG was used in the case. And if you watch me for a long time, you'll know that I did a video about that particular news article that was released early in the case, and I even researched the company that released it and their ties to the federal government and how they are basically just a mouthpiece for releasing information that they wanted released. Obviously, they wanted this information out there about the IGG in the public sphere, yet they didn't want it in the court process in this case for some reason. So it was very interesting. They obviously wanted IGG to be known in this case, but they didn't want it to be known in the actual litigation of the case. So they litigated it. They asked for all the discovery. They got as much as they could. could never get it all, and it resulted in some court battles. And what we finally came to learn in the end of all of these court battles were the defense would never get all the information that they desired to have about the IGG. Therefore, since they couldn't get it in discovery, they asked for a motion in limine just excluding it altogether. At the same time, the state, not wanting all the information about the IGG to come out, agreed and filed a motion in limine of their own, saying we don't want it to be brought up either. And it was a very strange thing as we watched it, unpack itself in court. And then the final determination by the judge was that both parties come together, stipulate to a jury instruction about the IGG. He granted both parties motions in limine to exclude the IGG evidence and told them to get together and come up with a jury instruction as it relates to the IGG and formulate some type of plan around how they would even bring up the fact that the investigators in the case got Bryan Kohberger's name through some tip. And we were like, what is going on here? They're going to exclude the IGG. That was how that led to Kohberger. So they're going to make up some lie about some tip and both agree on it. And that's what we're going to do at trial. And we were perplexed and we really wanted to know, well, what the heck are they going to do at trial as it relates to the IGG? What is this agreed upon jury instruction? Well, we now have it. They've now unsealed it, so we know. So we're going to go through and look at it so that we finally know for ourselves what the jury instruction was going to be. But we're also going to look at the impact that that would have had on the trial, especially as it relates to, as you'll see in this unsealed court doc, the one person who was going to have any relative testimony as it relates to this subject, which was lead detective Brett Payne. And then I'm going to show you some things that will blow your socks off. And if it would have went to trial, and if it ever does go to trial, it'll blow everybody's socks off. Hold on to your hats, folks. So on May the 9th, apparently this whole thing was almost agreed upon by the parties. And you can see right here it says the parties joint proposed jury instruction regarding tip leading to the investigation of the defendant. And it says, comes now, this was filed by the state, obviously, but it says, come now, the state of Idaho and defendant, Bryan Kohberger, to submit the proposed jury instruction as provided below. So it says the state of Idaho and the defendant, Bryan Kohberger, basically are agreeing to submit the proposed jury instruction. In its April 18th, 2025 order memorializing oral rulings on motions in limine, the court advised parties to meet and confer regarding a jury instruction to explain the tip that caused law enforcement to investigate defendant. The parties have agreed on the proposed jury instruction below, which relates to the testimony of MPD Corporal Brent Payne. It should have been Brett, I believe. And you can see the state intends to ask foundational questions of Corporal Payne to elicit the testimony addressed in the proposed instructions. Specifically, the state intends to, and look where it says I right here, ask whether law enforcement received tips that it investigated between November 13, 2022 and December 19, 2022. And then it's got two I's right here. If any of those tips had been substantiated, and then finally with the three I's, if law enforcement received a tip on December 19, 2022 that caused them to investigate defendant. Now, it's important to separate this because as you'll see right here, defendant does not stipulate to parts I and 2I. So the defendant does not stipulate to whether law enforcement received tips that it investigated between November 13th and December 19th, and defendant does not stipulate if any of those tips had been substantiated. But the defendant does stipulate to if law enforcement received a tip on December 19th that caused them to investigate defendant. But they do not stipulate to parts 1 and 2 of the anticipated testimony and reserves the right to cross-examine Corporal Payne about that testimony, but will not address investigative genetic genealogy. So the state's going to put Payne up, elicit whether they received tips and if any of them had been substantiated, and if they received a tip on December 19th that said, hey, investigate Bryan Kohberger for the crime. The defense is going to hammer whether law enforcement received tips, if they substantiated any, and then they're going to agree that a tip came in for them to investigate Kohberger on December 19th, but never ever discuss investigative genetic genealogy. And if just in case anything comes up about investigative genetic genealogy and any questions by the jury came up about what about this tip that they got, here was going to be the proposed jury instruction agreed upon by both parties. You heard Corporal Payne testify that the investigation team received a tip on December 19, 2022 that caused them to investigate the defendant, Bryan C. Kohberger. The testimony was admitted for the limited purpose of explaining what caused law enforcement to investigate the defendant. You are not to consider this testimony for any purpose other than the limited purpose of when and why law enforcement first investigated the defendant. You are not to speculate as to the source or substance of the tip. So no IGG needs to be brought up, no speculation about it, just a generic tip like, hey, Brett Payne, look at Bryan and see if he is a candidate for a suspect in this case. That's important to note because how the questioning of Brett Payne would have gone after that is very, very interesting, and allow me to explain. Now, it's important to keep in mind that the defense knew quite a bit at the time of this agreed upon tip, and they had a plan, I'm sure. But I'm going to include some of the things that the defense would have known at the time, but I'm also going to include some of the things that they would not have had access to at that time. So just imagine, based on their plan at the time, coupled with what they have at their fingertips now, if this thing ever does get somewhere. Hold on to your hats. So considering in the document the only person that they named that could even speak to this generic tip would have been lead detective Brett Payne, we can imagine a scenario like this. Once Payne is on the stand, and we don't know who's been on the stand up until this point, but we can assume. But once he's on the stand and he's asked about the investigation into the case and the fact that he received a generic tip on December 19th, 2022 that said, look at Bryan Kohberger. That could be the only thing that the tip could have said, is just look at Bryan Kohberger as a possible person of interest. So Payne would then have to go through his progression, much like he put in his probable cause affidavit. Now, the first thing he would have done is, just like in the PCA, he would have said, well, the first thing we did was pull Kohberger's license, and he matched the description from his appearance on his license that Dylan had given us of the possible perpetrator. Now, we don't know at this point if Dylan had been questioned on the stand or not, but whether she had or not, whether it already had happened or it was going to come later, imagine what would really happen as it relates to the Dylan description, right? This had probably been already discussed, I imagine, at this point, which would have made that look pretty dumb.
About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. At page 406, I don't know if this was real or in my mind was just like playing with me. Being drunk.
That wouldn't have played out real well about the description on the license matching the suspect, But I imagine at that point they would move on to what he had next, which was his queries of Bryan Kohberger in the system. And it showed he had a car that didn't line up with the year model that they're looking for. And this would have been backed up very strongly at this point by the defense. And we know that through their submissions of their discovery request to the prosecution. As you can see in this Exhibit F to Defendant's 6th supplemental response to discovery to the prosecution, they had originally filed under seal, but now it's not under seal. And you'll notice starting at 5 here, we have press releases by the Moscow PD listed under the defense discovery. And those press releases go all the way up to December the 19th. And then it just keeps on going all the way up until the last press release on January the 3rd. So they're discovering the Moscow PD's press releases to the prosecution. Why do you think they were doing that in large part? Well, I can tell you because from December 7th all the way through December the 22nd, well, they had made a huge mistake in their press releases. And that was provided to us by the defense in the change of venue memorandum. Because when you go to the defense's change of venue memorandum and you see that they included all of the MPD press releases, starting on December the 7th, Moscow PD put in their press releases that they're looking for an 11 to 13 Hyundai Elantra and put stock photos of that Hyundai Elantra that they're looking for in their press releases. And it didn't stop there. They put large photos that be on the lookout, everybody, starting December 7th. But then they continued December 8th, attaching that same 2011 to 13 Hyundai Elantra in their press release. Followed up December 9th. They included the same thing. December 10th. Included 11 to 13. December 12th, they included 11 to 13. They continued to include 11 to 13 and those pictures of that 11 to 13 model car all the way up through, let's see, December 20th. Oh, they're still in there. 21st. All the way up through, oh, look, they stopped putting it in there on December 24th. But even all the way up through December 22nd, they included the 11 to 13 Elantra that they were believing was involved somehow in the crime. Then it's even further backed up by police reports. As you could see, they would have had this report from Dustin Blaker that from November 25th through December 12th, he was still gathering information from police agencies around Moscow in reference to any 2012 to 13 Hyundai Elantra, validating even further that they were never looking for the year model that Bryan Kohberger had. So that would have been an awkward moment in court as he tried to explain that. Then I'm sure they would have moved on to what was next in his investigation, which was he learned of the WSU cops querying Elantras on the WSU campus and finding Bryan Kohberger's car, 2 different WSU officers. But then this probably would have come up, which would have been very awkward.
He had a white Hyundai Elantra, which, one of the reasons it wasn't submitted, other than just being outside the year range, is there's a lot of those around. It's interesting when you start looking for a certain make, model, and color of a car, how many there are. And so I know they were receiving hundreds of tips a day. And this would have been just another tip that, again, didn't meet the criteria that they were looking for. They had no evidence against Bryan Kohberger. They had nothing pointing towards Bryan Kohberger. There were lots of people out there driving white Hyundai Elantras. And so I don't think that they were interested in interviewing everybody that had a white Hyundai Elantra. I think they really wanted to work more towards more direct evidence on identifying a suspect. Because when you start interviewing people that you don't have any information really connecting them to the crime other than the make, model, and color of a car, it's hard to press somebody into determining really how much of a suspect they are.
Doesn't look like that would have played out too well for him either. But then he learned that, according to his affidavit of the investigation, that Bryan Kohberger was a WSU student and he had conducted Reddit surveys of inmates. And maybe that was something that would raise an eyebrow. Mr. Thompson said, "I don't think we can definitively say that because it's equally likely that this is just what people who are studying criminal justice are going to be reading." So now, I guess at this point, Bill has debunked that one. So that wouldn't have added any merit to the investigation. What happened next there, Brett? Oh, he then cross-references his phone with the geofence, and his phone doesn't appear to have been in the area based on that. So the FBI did a geofence around the area for phones and Google accounts. And they took Kohberger's phone, compared it to the phones in the area, and his wasn't in there. So shouldn't the investigation have stopped there, Mr. Payne?
His phone's not in the area, Darren. What do we do?
Maybe that means he's not a suspect.
Wait. His phone. He turned it off. He's a criminal.
So instead of excluding him as a suspect based on proximity, you decided to move forward because criminals sometimes turn their phone off. Is that right, Mr. Payne? And then you obtained a warrant for his AT&T phone. So first you got one for 48 hours to see if you could determine if he maybe was in the area at the time. And how did that one work out for you?
Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122.
Well, if you don't have evidence at this point that he had contact, then I imagine you didn't get any evidence from that 48-hour warrant that he had contact. So did you stop there? Nope. We continued on and we got a warrant for 6 months because we wanted to see if he was stalking the house, according to your affidavit. And it pinged in that area 23 times. Now that area does cover, shopping centers and everything else, but did it lead you to any more evidence that Bryan Kohberger was responsible for this crime?
The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122.
So once again, according to the lead prosecutor in the case, that warrant didn't turn up any more evidence to allude to Bryan Kohberger being involved in this crime either. So did you stop there and try to investigate further, or did you jump right to the last step? Oh, you jumped right to the last step based on basically nothing at this point. You made the decision to obtain trash from Kohberger's parents' house, and then you matched his father's DNA to the knife sheath. Is that right? Okay. Now, could you match Kohberger's DNA to any of the other evidence that was found at the crime scene, like unknown other male DNA blood? And wouldn't that have had an impact if you couldn't?
If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters.
But it really didn't matter though, did it? Because you went ahead with the arrest warrant and arrested Bryan Kohberger. Now, Since the arrest of Bryan Kohberger, you have had 2.5 years to really investigate very, very thoroughly to determine if Bryan Kohberger was the real assailant in the crime. Some of the questions I would have are, have you ever found evidence in Bryan Kohberger's car or his residence that linked him to the crime in any way? Have you ever found any evidence that linked Bryan Kohberger to the victims in any way? Did you ever find a knife? Did you ever find a connection to the Mad Greek restaurant where some of the victims worked? Was there ever a connection made to Papa Rogers that people speculated that was Bryan Kohberger? Did you ever connect him through evidence on his phone or his laptop? Were you ever able to come up with a legitimate motive for Bryan Kohberger in this case? And final question, have you ever even come up with a working theory of this case, Detective Payne?
And then maybe the car being completely empty of any blood, DNA connection, maybe that matters a little bit more.
What is your working theory, Bill, about this crime and why he did this? I mean, you have to have some type of working theory. I mean, juries like to hear stories. You have to tell the jury a story. So what was your working theory here about why Bryan Kohberger went to King Road that night and who specifically he was targeting?
Well, Anjanette, going into trial, we really weren't going to be proposing a working theory like you just discussed.
Did you ever find the knife or the clothes? And if not, doesn't that mean that you really don't know what the weapon was?
Well, I can just tell you, and forgive us if we go back and forth, it's just kind of how we roll. There is no evidence that we found that would lead us to any specific, even general location as to where the murder weapon or the clothes have been. And we searched. I mean, the FBI, again, to their credit, we had folks doing soil samples and so all sorts of things to try to come up with somewhere to start searching for these things, and we just never found it. So I'll let Darren speak to
that.
Yeah,
and on the weapon, it wasn't a lack of trying. Everywhere that we had evidence of where he went, based upon phone records, based upon the evidence that we had gathered, we searched that. We went there. We did searches on the ground, in the water. We did searches. We sent soil samples to try to figure out maybe where a shovel had been used. So we searched everywhere that we possibly could, but the reality is we're looking for a singular small, it's not that small, but K-bar knife, and that's it. So
Morons.
Okay, how was he able to avoid having any forensic evidence, such as blood transferred to his person?
Right. So the reality is that somebody can carry this out and still not get covered in blood. That's the reality of it, and this does happen, and there's plenty of studies of that. And we've had some of the world's experts that we've asked those same questions, because we've struggled with that. Why do we not find more here and there? And the reality was, if somebody has the training, if somebody has thought about it, if somebody wears the right type of clothing, that could be the outcome, and that's what we were left with.
Morons.
Maddie Mogan's fatal injuries. It also encompasses all of these injuries and possibly many more. Over 17 plus wounds, and that's just all that they've told us up to this point. It could be many more. Then we go to Ethan on the right side. A scalp wound on the left and center side. Wounds on the back of his left thigh. Wounds on the inside of his thigh. 9 plus wounds that we know of on Ethan. And then there's Xana. They did not list 50 plus wounds here. So that's how we know there's many more of these wounds just on Xana. So we can imagine there's probably many more on the others as well. Then we have Kaylee. When you think about Kaylee and 30 plus injuries.
So the reality is that somebody can carry this out and still not get covered in blood. That's the reality of it, and this does happen, and there's plenty of studies of that. And we've had some of the world's experts that we've asked those same questions, because we've struggled with that. Why do we not find more here and there? And the reality was, if somebody has the training, if somebody has thought about it, if somebody wears the right type of clothing, that could be the outcome, and that's what we were left with.
Morons.
Just thinking of the Richard Allen confessions, did you monitor Bryan's communications?
Yeah, we did monitor it, both while he was housed in Latah County and then once he was moved down to Ada County.
How many hours of communications did he have?
We have hundreds, thousands of hours of monitoring that was done, but there was nothing of evidentiary value that was gained from any of it.
So, just so we are clear, so far you have no weapon, no other forensic anything other than the touch DNA on a sheath, and you have monitored thousands of hours of communications he has had and not one word that leads toward his guilt?
Morons.
Considering we hear creators on YouTube reacting to jailhouse communications of inmates every day, and we have all heard the Richard Allen confessions he made on jail calls, will you be releasing Bryan's, or are you going to give us another one of those BS answers like it's not our policy to release those?
That's a good question. It's my understanding that the jail will not be releasing things that involve personal conversations with third parties. That ultimately would be a decision because the recordings are the possession of the two correctional facilities or detention facilities. But I'm pretty certain the Latah County Sheriff's Office policy does not allow for that, and I would guess Ada County is similar.
Was Bryan following any of the victims online?
So, trust us, we wanted that to be the case. We've looked for a link, and we have not found one. Not one.
Yeah, through the entire investigation, I think that's something that we need, that you want, is to help to understand this and say, well, what's the connection? What was the link? And so we had every resource possible, and we worked that tirelessly, both from everything from his side, but all the victims and all the members of the House from their side. So we have never, to this date, found a single connection between him and any of the 4 victims or the 2 surviving roommates.
In a case like this, the jury always would like to know a motive. Do you have any answers at all to what his motive was?
We don't.
Morons.
Thinking about all of the mainstream minions out there in particular, they have long suggested that Bryan's sister sent in a lead that led to his arrest. Is there any truth to this?
The only thing I'm really able to talk about is that we didn't get any tips or any evidentiary items from the family.
Morons.
In the new book by Vicky Ward and James Patterson, as well as the new Amazon docuseries, they suggest that Bryan met Maddie at the Mad Greek restaurant and began stalking her from there. Is there any truth to this?
But we never found any evidence at all from interviewing everybody that we possibly could, talking to every person that would have that information to be able to show that he was there or that there was a connection through the restaurant.
Since the beginning of this case, Pavarotti has said why you knew this was a targeted attack. Can you defend your investigation and give us a clear answer why you said this was a targeted attack and prove Pavarotti wrong?
That question over to the investigators to answer that one.
Well, I think Darren and I have, the evidence suggests that there was a reason that this particular house was chosen. What that reason is, we don't know. We don't know who the target was, and we're not going to speculate on that up here today. But we can tell you that for whatever reason, Mr. Kohberger chose that residence. Perhaps it's the location, layout, we don't know. But that's, to the best of my knowledge, that's what that statement likely led to.
Morons.
Last question. Even though it was debunked several years ago, the book and docuseries has all of the mainstream morons and their minions claiming Bryan to be the online personality Papa Rogers. Is there any truth to this at all?
Right. There was no connection. There wasn't at all. And we looked into every bit of it. We took a deep dive into it. We researched it. We utilized.
In black and white. Was Bryan Papa Rogers?
It was not. It was not. Thank you. We can cut that off.
So, Detective Payne, in light of everything that you now know, and over 2.5 years of investigating into Bryan Kohberger's connection to the crime, the most you could come up with is there's possibly evidence on his phone, but we'll never know because we think he wiped his phone. So nothing exists there. Possibly somebody in his family at some point maybe purchased a similar knife as the one that matched the sheath in the crime, but that was 8 or 10 months before he ever moved there, and there's no way you can even verify that it was him that purchased it. And other than that, over the last 2.5 years, even though it was very weak for you to issue an arrest warrant, you've literally found nothing else to corroborate your arrest. And you are standing here today prosecuting Bryan Kohberger for this crime? Are you a moron? Please like and subscribe to this channel. Post your comments, thoughts, criticisms. It's amazing when you think about something as simple as a generic tip and not being able to testify to the IGG and all the statements that have been made since the end of this case, what would happen now in a court of law. I think it's not what people would assume would happen. Pavarotti's out.
Oh, gonna give it a shot. Only one of me to shield you all from the